Good morning. I hereby call to order this fourth meeting of the Pennsylvania Public Utility Commission for the year 2018 and ask that you rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. First of all, let me please note for those of you that are joining us today in this hearing room, note that the exits for this room are down the stairs on either side of the hallway outside. In a true emergency, a PUC employee in an orange vest will be there to help those who need assistance. Once you move down the stairs, please exit onto North Street. Also, for your convenience, the restrooms are located on the atrium level, one level below us, near the cafeteria. Our first order of business for this morning's agenda is the approval of the minutes from February 8th, 2018, and I recognize Vice Chairman Place, who is the editor.
Thank you. I've reviewed the minutes of February 8th, 2018 and of the public meeting, and move that they be approved as submitted.
You have heard the motion for the approval of the minutes. Is there a second?
So moved.
Second by Commissioner Sweet. Any discussion, edits? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. This time we will move on to our agenda, and I will call up our Director of Office of Special Assistance, Cheryl Walker-Davis, to lead us through this morning's agenda.
Thank you, Madam Chairman. Good morning. Good morning, Commissioners.
Good morning.
May it please this Honorable Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items commencing this morning with matters on behalf of the Commission's Bureau of Audits. It is recommended that the Commission adopt the 3 recommendations appearing on page 1 regarding the release of various audit reports.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning now to page 2 of the public meeting agenda, pursuant to Act 50 of 2017, the Commission is responsible with regard to the implementation of Pennsylvania's one-call system responsibilities to appoint 13 individuals to serve as members of a damage prevention committee. It is recommended that the Commission adopt, on behalf of the Office of Executive Director, the recommendations for the appointment to that committee.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Well, I would just like to say under my discussion, as you can see, my appointment is that of Paul Metro, and I just want to congratulate Paul. I know he will do an excellent job. No further discussion. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters on behalf of the Commission's Office of Special Assistance, with regard to the first item, the recommendation pertains to the complaint of Ryan Ingram versus Pico Energy Company.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Under discussion,
I have a motion, Madam Chair.
Commissioner Sweet.
Please place my motion upon the record as if I had read it in its entirety. During the course of the litigation of this particular consumer complaint, there developed a question of whether the complainant had been properly served with pleadings in the initial decision. To ensure that the complainant is afforded due process, my motion remands the matter to the Office of Administrative Law Judge to give the consumer the opportunity to respond to preliminary objections and to participate more fully in the litigation. Therefore, I move that the initial decision in this matter is revoked, the case captioned Ingham versus Pico Energy Company is remanded to the Office of Administrative Law Judge for proceedings consistent with this motion, that Ryan Ingham shall file a response to the preliminary objections of Pico Energy Company within 10 days of the entry of this order, that the case shall proceed from that point consistent with Commission practice and regulations, And finally, that the Office of Special Assistance prepare an appropriate order consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Vice Chairman Place. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, is there any further discussion? If not, is there any objection to taking the previous roll call? Seeing no objection, the matter as amended passes 5-0.
With regard to the complaint proceeding of West Goshen Township versus Sunoco Pipeline LP, it is recommended that the Commission adopt OSA's recommendation pertaining to the petition for reconsideration of the Commission's January 9th order with regard to the construction of Valve 344 on the Janiac 2 tract.
Is there a motion to adopt the staff? Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
Yes, if I may.
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my statement be entered into the record as if I'd read it in its entirety. Before us today for consideration is West Goshen Township's petition requesting reconsideration of the Commission's January 2018 order, or, in the alternative, certification of the order of the Commonwealth Court in the above captioned proceeding. The Township is requesting that the Commission reconsider its January 2018 order and reinstate the injunction to preclude Sunoco from performing any HDD or pipeline construction activities that are inconsistent with installing Valve 344 on the SPLP use area until the Commission makes a final determination on the Township's currently pending formal complaint. Sunoco Pipeline LP opposes the Township's request because the company argues that the Township is seeking a different injunction and its pleadings are untimely. In addition, Sunoco in its answer requests that a separate settlement judge be appointed pursuant to the Commission's regulations to determine if the parties can resolve the remaining issues in this litigation. Further, Sunoco indicated that the Township had intended to use the Janiac 2 property for a potential development of a retirement home project prior to Sunoco's ownership of that tract of land. Through an established settlement process, Sunoco indicates that it is willing to revisit the issue of development of the Janiac 2 property with the Township. I dissented from the Commission's December 2017 action regarding the issue of discontinuing the injunction against Sunoco because I believe that the parties needed to address and document Sunoco's change in construction plans concerning the location of Valve 344 and to seek and negotiate a settlement to the 2015 settlement agreement. At that time, I believed that it was expedient and necessary for the parties to amend the 2015 settlement agreement first, before asking for a discontinuance of the Commission's October 2017 injunction. Today, I continue to believe that the parties can and must pursue settlement negotiations in this matter and reach an agreement in a timely fashion so that both parties are clear as to the change in Sunoco's construction plans and their obligations going forward. A negotiated settlement needs to be reached in this matter, and those settlement talks can take place within the current proceeding or through the process suggested by Sunoco. No matter the course, once the settlement is reached, the parties should submit a revised agreement, request approval by the administrative law judge, suspend the litigation schedule, and bring the matter before the Commission for final disposition. By amending the 2015 settlement agreement with Sunoco's updated construction plans in an expedient manner, the parties will be accorded the appropriate protections that a written modification provides, as well as bring finality to these proceedings. To do otherwise is continuing to waste the parties and this Commission's resources. Therefore, I will be dissenting.
Thank you, Vice Chairman. Any further discussion? I do have comments for the record, which I asked to be submitted in its entirety, and I will just summarize them for you. On January 9th, 2018, I voted not to rescind our prior injunction. However, my vote was in the minority. For purposes of this petition, the legal standard requires West Goshen to raise new and novel arguments not previously heard under the Dewick standard. The instant petition reframes the Township's previous argument that Sunoco is obligated under the settlement agreement to locate Valve 344 on the SPLP use area. This is not a new argument. The only persuasive argument raised by the Township that I would classify as a new or novel One pertains to the safety-related issue of how the valve should be spaced along the pipeline. However, the evidence relied upon by the township to support this argument was not part of the record before us when the commission voted on January 9, 2018. As such, I am unable to base my decision here on that evidence, as that evidence was not subject to cross-examination. Therefore, even though I would have preferred that the commission's prior injunction remain in place, because West Goshen Township has not met its burden under the Do-It case, I will vote to deny reconsideration of the January 9, 2018 order. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
Opposed.
The motion passes 4-1, noting the dissent of Vice Chairman Place.
It is recommended that the commission adopt the Office of Special Assistance recommendation with regard to the petition for interlocutory review, again filed in the matter pertaining to West Goshen Township versus Sunoco Pipeline and pertaining to a modification of the procedural schedule.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Bureau of Technical Utility Services in omnibus fashion, it is recommended that the Commission adopt the items appearing on pages 4, with the exception of the second item, Elverson Water Company, Inc., which has been withdrawn by the Bureau. The omnibus continues with all items on page 5 through and including the last item there appearing pertaining to the letter notification of Mid-Atlantic Interstate Transmission, LLC.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the recommendation of the Bureau of Technical Utility Services in the matter involving the Commonwealth Telephone Company, DBA Frontier Communications, Commonwealth Telephone Company's 2018 Price Stability Index Service Price Index Report filing.
Is there a motion to adopt a staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Under discussion, I will state that consistent with Section 1102 of the Commonwealth Ethics Act, I will recuse myself from this matter because my brother is employed by Frontier Communications. Is there any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 4-0, noting my recusal.
It is recommended that the Commission adopt the remaining items on page 6 involving Arlington Telephone Company, PPL Electric Utilities Corporation, and Hanover Municipal Waterworks, as well as the first item at the top of page 7 pertaining to the security certificate filed by Pike County Light and Power Company.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
The next recommendation pertains to the application of DishNet Wireless LLC for approval to discontinue and abandon the provisioning of competitive local exchange carrier and inter-exchange carrier reseller services in the Commonwealth of Pennsylvania.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Under discussion.
I have a motion, Madam Chair.
Commissioner Sweet.
Would please ask that it be entered into the record as if fully read. This case involves a request by DishNet Wireline LLC to waive a commission regulation requiring it to pay a $350 fee when filing an application to abandon service. Since its certification in 2012, DishNet has been on notice that if its business plans change or it does not provide timely service, it must request permission to abandon its certificate or face revocation. Despite being granted several extensions of time to begin providing service, DishNet still has no current plans to do so. In January, we rejected DishNet's fourth request for an extension. to begin providing service. The company then filed this application to abandon and requested a waiver of our standard application filing fee. In support of their waiver request, DishNet contended that its application was submitted, quote, to obviate the need for further commission action, close quote, and that action on the application, quote, is anticipated to require minimal commission resources, close quote. We disagree with DishNet's premise that it is doing the commission a service or a favor by voluntarily filing to abandon its certificate. The obligation to seek permission to abandon services is within the continuum of regulatory obligations DishNet assumed upon its certification. Further, remaining in good standing before the commission has value. Choosing voluntary abandonment over forced revocation serves the company's interests more than it obviates commission action. I also dispute DishNet's opinion that minimal commission resources are involved. Action on the application has already implicated the resources of the Secretary's Bureau, the Bureau of Technical Utility Services, and each individual commissioner's office. The fee at issue here is not substantial, but the principle behind the waiver is important. A request for a waiver of a regulation must be reviewed on an individual case basis and substantiated. This case does not involve, as we often see, a defunct business that lacks the financial resources to pay a filing fee. DishNet, in all reports, is a viable ongoing business that simply has never pursued the business plan it anticipated. The choice to abandon or really eschew the provision of Pennsylvania jurisdictional service is entirely DishNet's. We agree with staff's recommendation to grant DishNet's application for abandonment, but reject the requested waiver of our regulation and the fee which would be owed and which is, in my opinion, far less than the resources this commission has already devoted to the subject. Therefore, we move that the recommendation be amended consistent with this motion. DishNet LLC should be required to pay the $350 filing fee within 20 days of the entry date of this order. Third, failure to pay shall render DishNet LLC out of compliance with this commission order and subject to enforcement action, including the potential imposition of additional fees, fines, or penalties. And the Office of Special Assistance should prepare an opinion or an order consistent with this motion. Thank you, Madam Chair.
You have heard the joint motion as read by Commissioner Sweet. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion? Hearing none. All those in favor on the motion, say aye.
Aye.
And I will be supporting and result only.
Result only. The motion passes 5-0, noting that Vice Chairman Place will be concurring in result only. I apologize for that. On the matter as amended. Any further discussion? Is there any objection to taking the previous roll call? Motion passes 5-0, noting that Vice Chairman Place is concurring in result only.
And it is recommended that the commission adopt the Bureau of Technical Utility Services recommendation in the matter involving the letter notification of American Transmission Systems, Inc. pertaining to its Cranberry Pine number 1, 138 kV transmission line tap.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning now to page 8 of the public meeting agenda and matters presented on behalf of the Law Bureau, it is recommended that the commission adopt the Law Bureau's recommendation with regard to the first item pertaining to the public utility status of Business Discount Plan, Inc.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
And it is recommended that the commission adopt the Law Bureau's recommendation with regard to the implementation of Chapter 32 of the Public Utility Code pertaining to the Pittsburgh Water and Sewer Authority.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Under discussion.
I have just a few comments to make, Madam Chairman. Today's issuance of a final implementation order to launch the Commission's jurisdiction over the Pittsburgh Sewer and Water Authority is a perfect occasion to recognize and thank the men and women of this commission for the laudable work they have done. I sat through a couple of the meetings. I've monitored the minutes. We've been out to Pittsburgh. It is indeed remarkable what our agency is doing to address the issues and set a platform for moving forward with PWSA. Today, we set the stage for addressing the service and financial issues that plague PWSA, first with a rate-setting process in June, followed up with a compliance plan in September. I'd also like to thank the people of Pittsburgh who have rallied together in support of the changes, as well as the executive team and employees at PWSA for their commitment in taking these challenges head-on. In recent months have shown us anything, there is a palpable sense of hope in Pittsburgh for a modern, efficient, and robust PWSA. I want to commend this spirit of optimism and community spirit. It's an honor and privilege to be associated with this dedicated effort. Now the hard work begins. Thank you, Madam Chair.
Thank you, Commissioner Kennard. Any further discussion?
Madam Chairman, I'd like to associate myself with Commissioner Kennard's statement this morning. Today is a significant milestone, and I don't think it should pass without comment from the bench today. This is a Herculean effort on the part of the commission staff to get us to where we are this morning with an implementation order. There's been a lot in the news about the Pittsburgh Water and Sewer Authority and the state of the system, and I think we'd all agree there are some significant challenges in this system, and that is certainly going to press the resources of this organization as well as those of the PWSA. So this is a significant point this morning. And again, I'd also like to commend the staff for getting us to where we are today. I realize this is one step in a process. I'm sure there will be many more ahead of us, but I want to commend the staff as well and thank them for a wonderful job. Thank you.
Thank you, Commissioner Coleman. Any further comments? Let me add my comments to the record also in concurring with the statements that have been made here today by Commissioner Kennard and Commissioner Coleman. I believe that we're up to the challenge at the commission, and I've said that to our staff, and so we are looking forward to all the hard work that is ahead of us. There's no further comments on the motion. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Office of Administrative Law Judge, and the matter pertaining to the initial decision of Deputy Chief Administrative Law Judge Pell in the matter involving Marta Abrantes versus Philadelphia Gas Works.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Under discussion, I am going to turn over the gavel to Vice Chairman Place to preside because I know I have a motion.
I'd like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
Thank you. On June 30th, 2017, Marta Abrantes, the complainant, filed a formal complaint against Philadelphia Gas Works, or PGW, alleging incorrect charges on her bill. The complainant alleged that her gas bills increased as a result of a gas leak that she reported to PGW on December 1st of 2016. She further alleged that PGW investigated her concerns and declared her home safe, only to come to her home on February 2017 in response to her high bill concerns, at which time PGW determined she did have a leak. The complainant requested that PGW adjust her bills to account for the leak that should have been fixed in December of 2016. The matter was scheduled for hearing on October 6, 2017. On the evening of October 5th, 2017, the complainant left a message for the administrative law judge stating that she was unable to attend due to a work conflict. The hearing was convened on October 6, 2017, and the complainant did not appear. PGW moved for dismissal for lack of prosecution. The ALJ dismissed the complaint with prejudice for failure to prosecute. Because the ALJ's August 14, 2017 pre-hearing order warned of the consequences of not appearing at hearing, and advised the parties that any continuances should be sent at least 5 days in advance of an evidentiary hearing, I agree with dismissing the complaint. However, I note that this complaint, if verified, raises serious safety concerns. Therefore, I believe the dismissal should be without prejudice, and the matter of PGW's response to the gas leak inquiry made on December 1st, 2016, and any related billing inconsistencies should be referred to our Bureau of Investigation and Enforcement for such further action as deemed appropriate. Therefore, I move that the ALJ's initial decision be modified consistent with this motion, and two, that the Office of Special Assistance draft an opinion and order consistent with this motion.
Thank you. Having heard the motion, is there a second?
Second.
Seconded by Commissioner Sweet. Any discussion?
I have statements. I would adopt the initial decision in its entirety, dismissing the complaint with prejudice. The initial decision in this case describes the circumstances of the complainant's failure to appear, and I quote, "Prior to the hearing of October 6th, 2017, my legal assistant informed me that the complainant left a voicemail message at 10:44 p.m. on October 5, 2017. This is the evening before the hearing, indicating that she would not be attending the hearing because she had to work. The complainant did not explain why she hadn't contacted my office earlier to explain that she had a scheduling conflict, did not explain why she hadn't contacted my office during office hours, nor did the complainant request a postponement of the scheduled hearing. I instructed my legal assistant to contact the complainant and advise her that the hearing would proceed if she as scheduled, and that a complaint would be dismissed if she failed to appear for the scheduled hearing. The complainant did not answer, so my legal assistant left her a voicemail message. To date, the complainant has not returned the call. The initial decision, which was served on the complainant, recommended dismissal. No protest to this outcome was lodged by the complainant in any way, shape, or form. This commission scrupulously offers multiple forms by which customers may avail themselves to resolve their disputes, including by informal complaint, formal complaint, and mediation. The formal complaint process, as chosen by this consumer, provides the opportunity to present one's case under oath in an administrative hearing before an administrative law judge. The utility is compelled to attend and defend against the complaint. A formal complaint hearing is costly to all involved. In this matter, the commission, as it does in all hearings, provided a procedural form and a hearing room, as well as appointed an ALJ to preside. Counsel for PGW was present with 2 witnesses. A court reporter was retained by the commission and in attendance, ready to transcribe the hearing. This investment in time, effort, and money by all involved creates an affirmative duty, in my opinion, the complainant to make herself, in this case herself, available to participate in the hearing under the rules, or at least explain why she could not, leaving an after-hours voicemail the night before a scheduled hearing about one's unavailability without any subsequent follow-up or response to subsequent follow-up by the agency is not a reasonable discharge of this duty. Therefore, I would vote with the ALJ to dismiss this matter with prejudice. I would further state that in terms of the motion, I would support I&E looking into this matter. I think it's a good idea that I&E be asked to look at the leaks and the allegation of leak and find out and discuss with PGW their follow-up. We don't need a docket to do that. We don't need an open docket number to do that. A referral can be undertaken at any time. So I would vote with the ALJ.
Thank you. I also have a statement on the matter. As noted, Ms. Abrantes informed the ALJ's office at 10:44 p.m. the evening before the hearing that she could not attend the hearing because her work schedule conflicted with the hearing time. Ms. Abrantes did not follow the procedures set forth in the ALJ's pre-hearing order, but she did notify the ALJ's office that she had to work during the time of the scheduled hearing. I support the action taken here today, as Ms. Abrantes' changed circumstances should be respected and considered, and is a common occurrence for consumers who file complaints before the commission. Frequently, individuals do not know their work schedules 5 days ahead of the scheduled hearing or are requested or required to work on short notice, even though they originally requested time off. In support of Chairman Brown's motion, I believe that the complaint filed by Ms. Brontes should be dismissed without prejudice in order that she be provided an opportunity to address any unresolved issues with the utility service provided by PGW. Thank you. Any further discussion? Seeing none, all those in favor signify by saying aye.
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 Any opposed?
Opposed?
The motion carries 4-1, noting the dissent of Commissioner Kennard. On the matter as amended by the motion, is there any objection to taking the previous roll call? Seeing none, the matter passes again 4-1, noting the dissent of Commissioner Kennard.
Turning now to page 10 of the public meeting agenda and the matter pertaining to the motion of Chairman Brown with regard to third-party electric vehicle charging, resale redistribution of utility service tariff provisions.
Thank you. I recognize Chairman Brown for purposes of her motion.
Thank you, Vice Chairman Place, and I ask that my motion be submitted to the record in its entirety. On June 15, 2017, the Commission issued a secretarial letter seeking comments on electric distribution companies' resale tariff provisions and how those provisions may affect the operation of third-party electric vehicles, or EVs, charging stations. The review of these comments reveals that there is a consensus point of view around an overarching concept, which is elimination of any regulatory uncertainty is an important step in supporting the build-out of electric vehicle infrastructure. The comments further show that various EDCs tariffs provide a lack of clarity and consistency throughout the state regarding the resale of electric vehicle charging. OCA, or the Office of Consumer Advocate, highlights the distinction between electricity for use as a transportation fuel and electricity as an essential public utility service. Advanced Energy Economy further elaborates on this distinction, stating that the third-party EV charging station businesses are unique and should be permitted to resell electricity to drivers as needed. In this vein of discussion, Sierra Club submits that an EV driver receiving charging service from a commercial operation is not a residential customer, and therefore the provisions of Section 1313 of the Public Utility Code should not apply. I concur with this position and believe that it would be prudent to foster further transparency of this distinction. Such transparency can be accomplished, as stated by PPL, through the development of tariff provisions for EV charging stations that establish clear terms and conditions for service. The Commission has already approved at least one tariff provision, which helps to reduce regulatory uncertainty in this area, that provision being Rule 18.1 of Duquesne Light's tariff. Based on my review and the record comments, I submit the following. The number of electric vehicles and corresponding infrastructure continues to grow throughout the Commonwealth. Elimination of regulatory uncertainty is an important step in supporting the continued build-out of electric vehicle infrastructure. There is a lack of clarity as to the resale restrictions applicable to third-party electric vehicle charging stations pursuant to electric distribution company tariffs. There is a lack of uniformity among electric distribution company tariffs relating to the application of resale restrictions on third-party electric vehicle charging stations. It should be the Commission's policy to remedy this clarity across the Commonwealth for the betterment of electric vehicle marketplace, in the Commonwealth. Therefore, I believe it is prudent to make third-party electric vehicle charging resale tariff provisions more ubiquitous among EDCs. In the interest of further reducing any existing regulatory uncertainty, and in the interest of supporting the advancement of Pennsylvania electric vehicle marketplace, I submit that a proposed policy statement be issued consistent with the form and substance attached to this motion. Therefore, I move that the Law Bureau prepare a tentative order consistent with this motion, that the tentative order, including Annex A to this motion, shall be published in the Pennsylvania Bulletin, that comments be due within 45 days following the publication in the Pennsylvania Bulletin, and the Law Bureau, with assistance from the Bureau of Technical Utility Services, shall review the comments and all the information provided therein, and shall present a final order to the Commission for consideration.
Thank you. Having heard the motion, is there a second?
Second.
Seconded by Commissioner Kennard. Any discussion?
I just want to thank the chairman for her hard work and that of her staff on this topic. It's important to clarify as we move forward and we evolve our policy on electric vehicles.
Thank you. I also have a statement on the matter. I would like to thank all commentators, including manufacturers, service providers, consumer advocates, environmental organizations, and of course, electric utilities. One pervasive theme was a request for continued collaborative conversation. While the Commonwealth has an active collaborative, the Drive Electric PA Coalition, in which Commission staff, including my own, are active members, that does not obviate the value of focused conversations within the utility context. I would welcome this opportunity and am interested in which additional EV topics are ripe for Commission discussion in support of adoption and infrastructure build-out. I look forward to additional comments and conversations as we proceed with the upcoming 45-day comment period and beyond. Any further discussion? Hearing none, all those in favor of the motion signify by saying aye.
Aye.
Any opposed? The motion carries 5-0. Gavel's yours, Chairman.
Thank you very much.
That does conclude the presentation of regular agenda items. Turning now to the carrying agenda. On behalf of the Law Bureau, it is recommended that the Commission adopt the 3 recommendations in the matters involving James E. Elliott versus Pennsylvania Electric Company, the matter pertaining to the Secretarial Letter and Tax Cuts and Jobs Act of 2017, as well as the ratification of the Commission's emergency order in the matter involving Sunoco Pipeline LP, aka Energy Transfer Partners.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that does conclude the presentation of public meeting reports.
Thank you very much. If there's nothing else to come before us, is there a motion to adjourn?
So moved.
Second.
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. I'm assuming there's no discussion. The meeting is adjourned.